Hello and good morning friends, welcome to the CEC-UGC live lecture. Dear friends, as you know that from time to time we talk on different subjects, we talk on different topics so that it becomes easier for you to get in-depth analysis on those topics, on those subjects. Dear friends, you might have heard or you might be knowing, and if not then we would like to tell you all that in the 10th schedule of the Constitution, anti-defection law has been explained, and dear friends, today we are going to talk on anti-defection law. We are going to understand what provisions are made regarding the anti-defection law and what guidelines could be introduced in order to strengthen the anti-defection law. So, for this discussion, dear friends, we have again with us in our studios Dr. Rakesh Kumar. Dr. Rakesh Kumar is an assistant professor in University School of Law and Legal Studies, Guru Gobind Singh IP University. So, without wasting any time, I would like to welcome our guest, Dr. Rakesh Kumar. Dr. Kumar, welcome to the EduSet lecture.
Thank you, Gitika. Good morning, listeners. In today's lectures, I am going to discuss about the various provisions regarding the anti-defections law. And I have divided my lectures in 3 parts today. In first part, I will give you some brief idea about the genesis of the provisions of the anti-defections law. In second part, I will try to analyze the various constitutional provisions pertaining to anti-defections law as provided under the 10th schedule of the Constitution. And in third part, I will take up how this provision has been judicially construed or judicially interpreted by the various High Court as well as the Supreme Court. And afterwards, I will try to analyze the recommendations which was given by the various committee regarding the strengthening the provisions of the anti-defections law. As far as the anti-defection law is concerned, first you try to understand as to what is the meaning of defections and how the term defection has been defined by the provisions. So, as far as the term defection is concerned, here the defection simply means the abandonment of the loyalty, duty or privilege of one's leader or cause. So, as far as the parliamentary democracy is concerned or parliamentary political life is concerned, it denotes a change of party affiliations or allegiance by the members of legislatures. Because if you see the original scheme of the Constitution, then originally the Constitution has not used the word political party anywhere in the Constitutions, though it was implicit because from very beginning we have decided to adopt the parliamentary form of the government, and under the parliamentary form of the government it was conceived by the Constitution's maker that we will have the various or multiple political parties, and these multiple political party would be required to seek the or solicit the votes of the electorate after the periodic intervals, and that periodic interval is being fixed to 5 years. It means after every 5 years there will be general elections, and that general elections political party will seek the mandate from the peoples, and after if the mandate has been given, then they will have the right to form the government or run the government. So, originally here the terms political party was not being used in the constitutions, but the political party term was specifically provided under the section 29 of the Representation of People Act 1951, and this political party has been given the solid foundations by the 10th schedule of the Constitution, which was enacted in 1985. So, as far if you see the history of the elections which was held in this country, that from very beginning the elections in this country is being contested on the basis of the party lines, and electorate or the voter has invariably voted for the particular political party on the base of their political ideology, their principles, their philosophy and their values, and the kind of the manifesto, kind of the agenda they have regarding the providing the good governance in the country. So, it is common knowledge of everybody that before the general elections, either it is for Lok Sabha or if there is a elections for the state legislative assembly, that every political party declare the political manifesto, and in that political manifesto, that political party provide informations to the voter as to if they will be given mandate to run the government, then what will be their agenda, what will be their policy, what will be their programs, and accordingly the voters, by going through the manifesto of the various political party, decided to vote either in favor of the one political party or in favor of the other political party. So, from very beginning the election this country was being contested on the party line, and only the negligible cases where the some of the independent member has got elected from the particular constituency, whether it may be the Lok Sabha constituencies or it may be the state legislative assembly constituencies, but that is the negligible as far the keeping in mind the total number of the seat for which the election is being contested. But in the mid 1960s, the country saw very unsavory kind of the political phenomena, and many of the elected representatives of the peoples left their party on whose ticket they got elected and joined the very opponent's party whose candidate they have defeated in such elections. So, this kind of the things was happening because we were not having any kind of provisions to check this kind of the unethical or unprincipled practice which was being followed by the elected members of the various political party. So, after getting elected from the one particular political party, they decided to give up their membership and they joined the other political party, and they were not subject to any kind of the disqualification. They were allowed to continue as a members of, and it is something which has threatened the very existence of the parliamentary democracy, and it is also something which has threatened the very stability of the government. So, and in most of the cases, if you see the kind of the defection which was taking place, where the elected members of one political party was joining the other political party, was that the here it is the lure of the office, it is the lure of the office or the desire to clinching to power which was playing a very prominent role in the minds of these elected representatives when they decided to give up their political party allegiance and they joined the other political party. And afterwards this phenomena has acquired such a dimension that in most of the cases here the conscience of the nations was rudely jolted when some of the elected members has left their own political party in the morning and they joined the other political party in the afternoons, and when they were being pressurized, then by evening they have been returned to the original fold. So, because of this kind of the activity here, the conscience of the nations was completely shaken, and it has given the new jargons in the Indian political parlance, that is the Aya Ram Gaya Ram. So, here the parliament took a very serious note of this kind of the unethical practice where the elected representatives are giving up the membership of their own political party and joining the other political party. And by taking the cognizance here, the parliament has decided to set up a high power committee under the chairmanship of late Baibi Chauhan to examine this kind of the unethical practice which was being followed by the elected members. And this committee was being constituted in 1967, and this committee has given the recommendation in 1969. And if you see the kind of the recommendation which was given by the Baibi Chauhan committee, that committee is popularly known as the Committee on Defections. Here the first observations of this committee was that the lure of the office played a very dominant role in the decisions of the legislatures to defect, as majority of them were included in the Council of Ministers, which they help in the bringing out this kind of defections. Because once you get defected and you join the other political party, then immediately you are being awarded in the form of providing the portfolio or become the ministers or the chairpersons or chairman of the some various other standing committee or the various other board. So, these kind of the lure of the office or clinching to power, which was the prime motive for these elected representatives to give up their allegiance to their original political party, and they were joining the other political party. As far as this committee is concerned, this committee has also made the various several recommendations suggesting various kind of the ethical, political, constitutional and legislative solutions to this problem. And these recommendations which was given by the Baibi Chauhan committee is concerned, here this committee has also recommended that if any such elected member if give up the membership of their own political party and if they join the other political party, then such defected legislature should be debarred from becoming the members of the ministry or the joining the Council of Ministry at least for the 1 year period of time, or unless he resigned from that seat and got himself re-elected. So, these were the vital decisions, these were the vital recommendations which was given by the Baibi Chauhan committee on the just to checking this kind of the unethical practice which was taking place in the working of the Indian parliamentary democracy. So, just to give effect to the recommendation which was given by the Baibi Chauhan committee, here the parliament has here the constitution's 39th amendment bill was being introduced in year 1973 for giving effect to the recommendation which was given by the Baibi Chauhan committee. But here this bill was not being passed by the Lok Sabha because of the dissolutions of the house in 1977. So, after this dissolutions, again the attempt was being made to introduce the positive measures in the form of the curbing this kind of unethical practice, and again the constitutional 48th amendment bill was introduced in year 1979. But even after the introduction of this bill, here the government was allowed to run for the complete period of 5 years from 1979 to 84, but here this bill was not being passed by the Lok Sabha because of the oppositions by some of the members of the Janata Party. So, here both the attempt in the form of the Constitution's 39th amendment bill and the Constitution's 48th amendment bill was being defeated. And if you see the recommendations which was given by the election commissions, then the election commission is a report from mid-term general elections in India in 1990 have also expressed their anguish over this kind of the unethical practice of the defections, which has adversely affected the stability of the government, and they have also sought the suitable amendment in the laws to check this kind of the unethical practice. And it is only afterwards when the Congress party headed by the Mr. Rajiv Gandhi in 1984 general elections, they have make a promise to the electorate by declaring in their election manifesto that if their government will come into power, then they will introduce the forward legislations for checking this kind of the unethical practice where the elected members are giving up the membership of their own political party and joining the other political party. And Rajiv Gandhi has also declared in the Congress manifesto that if the government will come into power, then they will also introduce the law related to the electoral reforms. And just to give effect to the promise which was made by the Mr. Rajiv Gandhi to the electorate in 1984 elections, here the bill for the purpose of providing the anti-defections law being introduced in the Lok Sabha, and this was stated by the President in the joint sessions of the both House of Parliament in the very beginning that this government is committed to introduce the anti-defections law, and this anti-defections law will be enacted in the current sessions of the Parliament itself. And if you see the object or the reason which was stated before the introduction of the Constitution's 52nd Amendment Bill, here the statement of the object and reason which was appended with the bill, it has clearly provided that the evil of political defection has been a matter of national concern, and if it is not combated, then it is likely to undermine the very foundations of our democracy and the principle which sustain it. So, this is the kind of the concerns which was being shown by the government at the time of the introductions of the bill itself, and this bill was being passed by the both House of the Parliament because that time the Rajiv Gandhi has got a very thumping majority in the Parliament, and they were having as many as 401 member to the Lok Sabha. So, this bill was being passed and it received the assent of the President on the 15th February 1985, and these provisions came into effect from the 1st March 1985, and this provision is this provision has added to the 10th schedule to the constitutions, and it has also amended the certain provisions of the constitutions pertaining to Article 101, Article 102, Article 190 and 191 of the constitution, which provided for disqualifications on the ground of defections. So, this is the history or genesis of the introductions of the introductions of the Anti-Defections Law, and this was enacted by the Constitution's 52nd Amendment Act in 1985. So, after giving you the genesis as to how and why this law was being enacted by the Parliament, now I am coming to the salient features of the 10th schedule of the Constitution. And if you see the salient features of the 10th schedule of the constitution, then it provide for disqualifications for 3 types of the members of the parliament, that is the Lok Sabha or Raj Sabha. The first is the elected members, second is the nominated members, and third is the independent members. And if you see the scheme, then what is being prescribed by the 10th schedule of the constitution is that if the elected member who has been set up as a candidate by the political party or nominated member who is a members of the political party at the times of the election, if he take his seat, voluntarily relinquish his membership of such political party. So, first ground of the disqualification which is being prescribed, that if the elected members or nominated members voluntarily relinquish the membership of the political party to which he belongs, then that case he will be subject to disqualification. If you see the scheme of the Representation of People Act is that before every elections, the recognized national level political party as well as the recognized state level political party are required to declare their candidates, and they are required to nominate to the returning officers to the every constituency that the particular person is their authorized candidate. So, if any candidate is being declared by the recognized national level or state level political party, then that case their nomination paper is required to be subscribed by only 2 proposers of that particular constituency. But if somebody is contesting elections, then that case here the such independent candidate nomination paper is required to be supported by at least 10 proposers of that particular constituency, and the candidate set up by the recognized political party will also have the benefit of the party symbols. So, if any person is being declared as the candidate from as their own candidate, the candidate of recognized political party, then they will be given the benefit of the symbols of that particular political party, and the symbol to the political party is being allotted by the election commission. So, here the first provisions pertains to the disqualifications to the elected members or nominated members, and the condition is that if he voluntarily relinquish his membership of that political party after his elections, after his taking his seat to the parliament or state legislature, then he will be subject to disqualifications. The second ground on which the elected members will be subject to disqualification is that the instances of the voting or abstain from voting against the directions or whips which was issued by the political party, because if suppose no confidence motion is being moved against the government, then that case here the political party in the governments or the opposition's political party, every political party are issuing the whips or directions to their elected members, and they are directing them as to how they have to vote, whether they have to vote in the favor of the no confidence motions or whether they have to vote against the confidence motions. So, if any such whip or direction has been issued by the political party to the members, and if the elected members of that political party had decided to vote either against the directions of whip issued by the political party, then that case also he will be subject to disqualification under anti-defection law. However, this is not an absolute provisions. Here what is being further provided by this provision that if that political party had decided to condone such act of the voting or abstain from voting by the members of that political party, then that case such persons will be not subject to disqualification, and this act of the condoning has to be done by that political party within 15 days from the date of such voting or abstain from voting. So, this is the second ground in which the elected members will be subject to disqualifications under the 10th schedule of the constitution. The third ground which is prescribed for disqualification is that if any independent members of the parliament or state legislatures join any political party after his elections, because here as far the independent elected members of the parliament or state legislature is concerned, they are having options either to provide the outside support to the government, or they can become they can provide the inside support, even they can become the ministers. There is provisions regarding them for becoming ministers, but if the such independent elected members of the, if they decided to join any political party after elections, then he will also be subject to disqualifications under the scheme of the 10 schedules. And the fourth ground on which the members will be subject to disqualification, that pertains to the nominated members. And what is being prescribed by this by the 10th schedule is that if the any nominated members joins any political party after the expiry of 6 months from the date on which he take his seat in the house, so then that case also he will be subject to disqualification. So as far as the nominated member is concerned, here the nominated members of the parliament, because the president is having the power to nominate the 12 members to the Rajya Sabha and the 2 members of the Anglo-Indian community, or here the governor is also having the power to nominate the certain members to the state legislative council. So if the any person is being nominated by the president or the governor, then that case such person has 2 options. Either after nominations he can remain the members without joining any political party, or he can join any political party within the period of 6 months from the date on which he take his seat to that particular house. So if the nominated members within the period of 6 months decided to join any political party, then that case he will not be subject to any kind of disqualification. But after the expiry of this period of 6 months, if such nominated members decided to join any political party in that house, then that case also he will be subject to disqualifications under the anti-defection law. So these are the basic scheme regarding the disqualifications to the members of the parliament or state legislatures on the ground of defections. But if you see the further provisions of the anti-defections law, then this provision has also recognized the 3 exceptions. And the first exception which was recognized in the favor of the that if the members of the parliament or state legislatures goes out of his party as a result of the split in the party, provided such group consists of not less than 1/3 of the total membership of that party in the house. It means originally when the 10th schedule of the constitution was being formulated, then it has provided a scope for the 1/3 split of the members of the parliament or state. So if the any political party 1/3 member has decided to join the other political party, then that case he will not be subject to any kind of disqualifications. So it means suppose any political party is having just 30 seat in the Lok Sabha, then that case if the 1/3, that is the 10th members of that political party had decided, if that 1/3 had decided to split from the original political party and form the new political party, then that case he was not subject to disqualification. But and when the constitutionality of this provision was being challenged before the court, then that case the court has upheld this provision by saying that it is providing the fair scope for the right to dissent by the at least 1/3 of the total membership of that particular political party. But later on what is being observed in the working of the 10th schedule is that here instead of the individual defections, here it has provided for the scope of the 1/3 split. So this provision was being sought to be rectified, and the concern was also being expressed by the various quarter that instead of the individual defection, it has somehow encouraged the defections large scale, and the smaller political party becomes very vulnerable to this kind of provisions. So the constitution, the parliament has took a cognizance of these provisions, and the parliament had decided to amend the 10th schedule of the constitutions, and this provision which pertaining to the which pertains to the which recognize the split by the 1/3 member was being omitted by the Constitution's 91st Amendment Act in 2003. So now there is no scope for the 1/3 split, because this provision is being omitted from the 10 schedules by the 91st Amendment Act. But the second ground in which there is a scope for the defections at a large scale is that in case of the merger which was supported by at least 2/3 of the members of that particular political party. And if you see the provisions, then what is being prescribed by this is that if the original political party merge with another political party, if not less than 2/3 of the members of the legislative party concerned have agreed to such merger. So in such case of the mergers, the elected members of that particular political party will not subject to any kind of disqualifications. But as far the consent by the 2/3 member is concerned, here what is being prescribed, that the out of the total strength, if the 2/3 of the member has decided to give the consent regarding the merger of that particular political party with the other political party, then that case such merger will be perfectly legal. But if the some of the members are still not in the favors of this kind of mergers, then such members can form their own group or the separate group, and such group will be given the recognitions by the speakers or the chair or the chairman of the Rajya Sabha or the legislative councils accordingly. So here now the only scope for the merger is that if it is supported by 2/3 of the total strength of that particular political party, then it can merge with the other political party, and it is something which is not going to strike on the stability of the government, but it is something which will provide the needful majority or provide the more stability to the political party which are providing the government at that point of time. And the third exception which was recognized in the favor of the speakers or the chairman of the parliament or state legislatures, including the deputy speaker or deputy chairman, to give up the membership of his own political party to which he belongs and rejoin that party or become the members of another political party. Because what is being prescribed by the 10th schedule is that if any person is being elected as speaker or chairman or deputy speaker or deputy chairman of the house, then that case, if he resign from the members of his own membership of his parents political party, then that case he will not be subject to any kind of disqualifications. And after completions of the term of the speaker or chairman or deputy speaker or deputy chairman, he will have the full liberty to join that political party again or to join any other political party. And this provision was being incorporated in the 10th schedule just to somehow to preserve the dignity, image and the impartiality of the persons who are holding the office of the speaker, chairman, deputy speaker or deputy chairman. And this provision was challenged before the Supreme Court also in the Luis Proto Barbosa vs. Union of India case in 1992, when the Supreme Court has disqualified the Speaker of the Goa Legislative Assembly because he resigned from his own political party and joined the new political party with some other members of the Legislative Assembly while still functioning as a Speaker of Legislative Assembly, because it is not permissible for such a speaker to join the political party and at the same time also occupying the office of the speaker or deputy speaker. So this 10th schedule of the constitution is subject to the basically the two kind of exceptions. One exception is being recognized in case of the merger supported by the 2/3 of the members of that particular political party, and the second was being recognized in favor of the speaker or deputy speaker, and the provisions pertaining to split is now being deleted or omitted by the constitution's 91st amendment act in year 2003. Now I am coming to some other the prominent provisions of the 10th schedule of the constitutions, and if you see the provisions, particularly the para 6, the para 6 of the 10th schedule of the constitutions, then it provides that if any questions arise as to whether a members of the house has been subject to disqualifications under this schedule, then questions shall be referred to the speaker or the chairman of the such house, and whose decision shall be final. It means if there is any complaint regarding the defections by the elected members of political party, and if it is forwarded to the speaker or chairman, then that case the speaker or chairman will have the right to decide whether such elected members will be subject to disqualifications under the 10th schedules or not, and the finality has been accorded to decisions of the speaker or chairman by the para 6 of the 10th schedules. But if the questions pertains to the disqualifications on the ground of defections or under the anti-defection law pertaining to the speaker or the chairman itself, then what is being prescribed by the para 6 is that any such issue needs to be decided by the house concerned. So it means the house has been given the power to decide if the question pertains to the disqualifications of the speaker or the deputy speaker or chairman or deputy chairman on the ground of defections, or if they have joined the other political party, as happened in the case of Luis Proto Barbosa case in the Goa, where he was serving as speaker at the same time he along with some other elected members had joined the other political party. Then other important question, the other important provisions pertain to the 10th schedule is that the para 7, and the para 7 of the 10th schedule of the Constitution provide for the bar of jurisdictions of the High Court and Supreme Court in the matter of disqualifications of the elected members of the Parliament or state legislatures on the ground of defections. And if you see the provisions of the para 7, then what is prescribed that the no court shall have any jurisdictions in respect of the any matters connected with disqualifications of the members of the House under these schedules. So, here this schedule has completely taken out the jurisdictions of the High Court under Article 225 and 227 of the Constitution, as well as the jurisdiction of the Supreme Court under Article 136 of the Constitution. And the constitutionality of this provision was being challenged before the Supreme Court in Kihoto hollohan case, where the Supreme Court has applied the doctrine of severability, and the Supreme Court has struck down the para 7 of the 10th schedule of the Constitution, which has provided for exclusion of the jurisdictions of the Supreme Court and High Court in matter pertaining to disqualifications to the members of Parliament or state legislatures under the 10th schedule of the Constitution. Then now I am coming to the para 8 of the 10th schedule, and it provides the power of the Speaker or the Chairman of the House. And what is prescribed by this provision is that it empowered the Chairman and the Speaker of the House to make rules for giving effect to the provisions of these schedules, and the rules are required to be laid before each House of the Parliament, and it will be subject to the modifications or disapproval by that House. And apart from this, the para 8 clause 3 is also very important, and what is being prescribed by this provision is that all the proceedings in relation to any question as to disqualifications of the member of the House will be deemed to be the proceeding in the Parliament within the meaning of Article 122, or proceeding in the legislature of the state within the meaning of Article 212 of the Constitution. Therefore, any contraventions of these rules which was being formulated by the Speaker or the Chairman of the House will be dealt as the breach of the privilege of the House. Then under the para 8 of the 10th schedule of the Constitution, here the rule is being framed by the respective House, and one of the I am taking here the important rules, and that rule was being framed for the members of Lok Sabha disqualifications on the ground of defections rules 1985 by the Speaker. And if you see the important provisions of this rule, then what is prescribed that here the duty is being imposed on the leaders of political party to furnish the details of the legislatures as well as the rules of the party, and that this information has to be provided by the leaders of that particular political party within 30 days of the formations of such party, or within the 30 days of the formulations of such rules and regulations. So, here the duty has been imposed on the leaders of that particular political party to provide such kind of details, and it is being further provided by the anti-defection rule that they are also required to inform to the Speaker about the changes that had taken place in the strength, its rules, regulations, etc. Here as far the changes in strength, changes as far the strength of that particular political party is concerned, it may be because of death or it may be because of resignation. So, if any such change has taken place with respect to the total strength of that particular political party, then it has to be accordingly informed to the Speaker or Chairman by the leaders of that particular political party. And the third important rule that pertains to the anti-defections is that they are also required to inform to the Speaker any instances of the members voting or abstain from voting contrary to directions issued by the such political party without permissions of the party, because if any elected members has voted or abstained from voting in contrary to directions of the whips or direction which was issued by the political party, then definitely in that case he will be subject to disqualification. So, here again the duty is being imposed on the leaders of that particular political party that they have to inform to the Speaker of any such instances where they have voted in favor or against the directions which was issued by the political party. And further the duty has been also imposed on the individual member to furnish informations regarding the party affiliation on the date of the elections or nominations to that particular house. So, these were some of the important rules that was being formulated by the Speaker for giving effect to the provisions of the para 8 of the 10th schedule of the Constitution where the speaker or the chairman was being empowered to formulate the rules. Now the questions will arise as to, suppose, because I have already stated that if any contravention has taken place with respect to any of the rules framed by the speaker or the chairman, then it will amount to the breach of the privilege of the house and it has to be dealt accordingly. Now the question will arise to, what will be the effect of the any breach of the such rules as far the member the continuations of their membership to that house is concerned. And this issue was being examined by the Supreme Court in Ravi Nayak versus Union of India case. And if you see the Ravi Nayak case, there the appellant Ravi Nayak has challenged the speaker order disqualifying him from the membership of Legislative Assembly on the ground that speaker had given them 2 days time instead of 7 days to reply before the disqualifying him, and he relied on the material like his photographs in the newspaper with MLA of the some other political party meeting the governor to form the new government. And when the constitution of this rule was being challenged before the Supreme Court, then the Supreme Court had laid down the following guidelines with respect to when there is allegations of the violations of the procedural rule framed by the speaker in exercise of his power conferred by the para 8 of the 10th schedule of the constitution. And the Supreme Court has stated that first, that the disqualifications rules are procedural in nature and any violations of the same would amount to the irregularity in the procedures which is immune from the judicial scrutiny in view of the sub paragraph 2 of the paragraph 6. The court further stated that judicial review in respect of the order passed by the speaker under the sub paragraph 1 of the paragraph 6 is confined to the breach of the constitutional mandate, malafide, non-compliance with the rules of natural justice. The violations of disqualifications cannot amount to the violations of the constitutional mandate. And the Supreme Court further stated that since the disqualification rule has been framed by the speaker under the paragraph 8 of the 10 schedules, the rule have status subordinate to the constitutions and it cannot be equated with the provisions of the constitutions. Therefore, any violations of the disqualification rule does not does not afford the ground of the judicial review of the speaker order in view of the finality clause which has been accorded to the speaker decisions under the para 6 of the 10th schedule of the constitution. So after examining the constitutionality of the rules which was framed by the speaker or the chairman under the 10th schedule of the constitutions, now I am coming to the constitutionality of the 10th schedule itself, because the constitutionality of the 10th schedule was being challenged before the Supreme Court in Kihoto, hollohan versus Sri Jaichullu and other case in 1993. And this case was decided by the 5-judge bench of the Supreme Court, and in this case there was the 4 important issue before the Supreme Court. So first come to the issue which was before the Supreme Court. The first issue before the Supreme Court was that the para 7th of the 10 schedules which sought to make the change in the chapter 4 of the part 5 or chapter 5 of the part 6 took away the jurisdictions of the Supreme Court under article 136 and High Court under article 225 and 227, and amendment was bad in law because it was not been ratified by the half of the state legislature before its enactment. The second issue before the Supreme Court was the very concept of disqualifications for defections was violative of the fundamental values and principles underlying the parliamentary democracy, and it violated the elected representatives' freedom of speech, right to dissent and freedom of conscience. The third issue for the Supreme Court was, it was also contended by the petitioners that that independent and impartial adjudicatory mechanism for resolutions of the dispute pertaining to disqualification is not being provided. And the fourth, the finality clause of the para 6 of the 10th schedule expressly excluded the jurisdictions of the Supreme Court under the 10th schedule of the Constitution. So these were the four important issues with respect to which the Supreme Court has to examine the constitutionality of the 10th schedule of the Constitution. So now I am coming to the first decision which was given by the Supreme Court. As far the constitutionality of the 10th schedule is concerned, here the 5-judge bench of the Supreme Court has while analyzing the entire scheme of the 10th schedule in the historical background by majority has upheld the constitutional validity of the 10th schedule except the para 7 which has provided for the exclusion of judicial review in the matters of disqualification. So, except the para 7 which was being struck down. So, the para 7 the 10 schedules which contain the provision which is independent and it stands apart from the main provisions of 10 schedules and which are intended to provide the remedy for the evil of unprincipled and unethical political defections, and therefore, it is a severable. So, but the remaining part is complete in themselves. Doctrine of severability I have already discussed when I was discussing the article 13 of the constitutions, and in that provision itself. So, here the doctrine of severability was being used by the Supreme Court by striking down the para 7 which has provided for the exclusion of judicial review in the matter of disqualification, and finality was being accorded to the decisions of the speaker or chairman. So, after the removal of the or after the striking down the para 7s, here if any such decision has been given by the speaker regarding the disqualifications on the provisions of the para 2 of the 10th schedule of the constitutions, then it will be subject to judicial review by the High Court under article 226, 227 as well by the Supreme Court under article 136 of the constitutions. The other important provision that pertains to that, it is something which is offending the right of the elected representative, the right to dissent, because here the under article 19 of the constitutions, here you have been given the freedom of speech and expressions, and the broad spectrum of the freedom of speech and expression also include the freedom to remain silent or freedom to dissent or freedom to express the opinion altogether different from the opinion of the majority, and this is the fundamental right of the constitutions. And here the article 13 clause 2 itself imposes absolute embargo on the parliament from enacting any law in violations of any of the provisions of the part 3 of the constitution. So, here in this case the main ground on which the petitioner had relied that it is something which is violative of the fundamental right, that is right to dissent or right to remain silent. So, these provisions cannot be given effect. With respect to this provision, here the Supreme Court has clarified that the para 2 of the 10 schedules is not violative of the democratic right of the elected members of the freedom of speech, freedom to vote, right to dissent and conscience of the members of parliament and state legislatures. These provisions are salutary natures and it is intended to strengthen the fabrics of the Indian parliamentary democracy by curbing the unprincipled and unethical political defections where the elected members are joining other political party not on the ground of the valid dissent, but it is purely on the grounds of the to become the ministers or some other monetary considerations. The other important things which was stated by the Supreme Court in Kihoto hollohan case was that the speaker or the chairman, while exercising the power and discharging their functions, act as a tribunals adjudicating the rights and obligations, and their decisions are amenable to judicial review. So, somehow the Supreme Court has assumed the power of judicial review with respect to any decisions which was given by the speaker or deputy speaker or the chairman or deputy chairman regarding the disqualifications to member of the disqualification of the members on the ground of the defections. But what is actually happening in the practice is that here the speakers are also being somehow being influenced by the political equations, and they are taking lot of times in deciding as to whether the member was subject to any disqualifications under the 10th schedule of the constitution, and sometimes the speaker are showing the promptness when the issue pertains to the confidence or no confidence motion against the government, because if the government has to prove the majority on the floor of the house, and if they are having any kind of doubts, and if there are some kind of allegations regarding disqualifications on the ground of the voluntarily giving of the membership is pending, then the speakers because of political considerations they are deciding the issue before the no confidence motion was taken by the house. And it is something which is not being expected, and the concern is also being expressed by in the academic circles as well the constitutional expert, that if any such matter is being referred to the speaker, then they are required to decide such issue on the promptly. Apart from this, here as far the positions of the Speaker or Deputy Speaker is concerned, here the Supreme Court has also clarified in Kihoto hollohan case by saying that here the Speaker or the Chairman holds a pivotal position in the scheme of the parliamentary democracy, and they are the guardians of the rights and the privilege of the House. So, they are expected to take a far reaching decisions in functioning of the parliamentary democracy. Therefore, conferment of the such power should not be construed as unexpected or exceptional in nature. So, in this way the Supreme Court in one hand upheld the constitutionality of the 10th schedule of the constitutions. Here the Supreme Court has also recognized the right to dissent as one of the fundamental right, but the Supreme Court at the same time has also assumed the power of judicial review, which was being denied to them by the para 7 of the 10th schedules, by striking down the para 7 by saying that it is something which is violative of the basic structure of the constitution, because the judicial review is already being recognized the basic features of the constitutions in the Keswan Bharti case way back in year 1973. So, after discussing the Kihoto hollohan case, now I am coming to the other expressions or term which has been used by the para 7 of the constitutions, and one of the expression which has agitated the minds of the court time and again as to what is the meaning of the voluntarily giving up the membership of the House, whether how this has to be inferred and how the members will be simply disqualified on the allegation that he has voluntarily give up the membership of that House. Here this issue was expressly clarified by the Supreme Court in Ravi Nayak versus Union of India case way back in year 1994, and here the Supreme Court has laid down the certain guidelines to examine the meaning of the as to voluntarily giving up the membership of the House. And the Supreme Court has stated first that any persons may voluntarily give up the membership of the political party even though he had not tendered resignations from the party. So, even in the absence of the formal resignations, an inference can be drawn from the conduct of the members that he has voluntarily give up the membership of the political party to which he belongs. It means for the construing the meaning of the terms voluntarily giving the membership, it is not necessary that he should formally resign from that political party. Even he is not tendered the formal resignations, but his conduct, so it is a matter of evidence, and the evidence has to be laid down by the party, by the persons of party who is alleging that he has voluntarily given the membership by joining the other group or coalitions. So, this is the first explanation which was given by the Supreme Court, and the Supreme Court has also stated that this act of the voluntarily giving of the membership may be expressed or implied, and the court has further stated that when any member is thrown out or expelled from the party and got elected and joined the other political party, then in that case certainly it will amount to that he has voluntarily give up the membership of that political party. But if such elected members by his own volitions join the other political party, then he must be construed or he must be taken as that he has acquired the membership of the other political party by abandoning or by giving up the membership of his own political party. So, as far this provision is concerned, here it has to be inferred from the conduct of the such members. And this issue was further examined by the Supreme Court in a very famous case, that is Dr. Mahachand Prasad Singh versus Bihar Legislative Assembly, Bihar Legislative Council, Chairman Bihar Legislative Council case way back in year 2004. What happened in this case is that here the petitioner was elected to the Bihar Legislative Council from the graduate constituency as a candidate of the Indian National Congress in year 1998. In 2004 general election, he sought a ticket from the Indian National Congress to contest the elections from the Maharajganj parliamentary constituencies, but the party has refused to give him the ticket. So, after the refusal of the party to give him the ticket to contest the elections as a Congress candidate from the Maharajganj parliamentary constituency, he decided to contest the elections as a independent candidate from the Maharajganj parliamentary constituency, and he lost the elections. So, after losing that parliamentary elections, his membership to Bihar Legislative Council was being challenged by giving complaint to the chairman of the Bihar Legislative Council that he was the members of the Indian National Congress, he was the members of the Congress party from the Bihar Legislative Council, and he has voluntarily contested the elections as an independent candidate. So, from his conduct it has to be construed that he has voluntarily give up the membership of that house. So, after receiving the complaint from the members, here the chairman of the Bihar Legislative Council had decided to give him to issue him the so called notice, and afterwards he also given him the personal hearing, and after giving the personal hearing he has disqualified him from the membership of Bihar Legislative Council on the ground that he has voluntarily give up the membership of the political party within the meaning of the para 2 of the 10th schedule of the constitution. So, when this decision was given by the chairman of the Bihar Legislative Council, then he challenged the propriety of the decisions before the Supreme Court, and before the Supreme Court he primarily took the two main grounds. His first ground was that there was violations of the principle of natural justice, as the materials relied upon by the chairman was not disclosed to him, and he was not given the proper opportunity to explain his positions. And second contention was that he has not voluntarily given up the membership of Congress party, because the Congress party itself has not taken any decisions regarding their continuations as a members of Congress party. So, he still continue to be members of the Congress party. Here the Supreme Court has rejected both their contentions, and the Supreme Court has stated that the first, that he had been elected to legislative councils on the ticket of Indian National Congress, but he contested the parliamentary elections as an independent candidate. So, inference can be drawn from his conduct that he has voluntarily give up the membership of the political party to which he belongs under the meaning of the para 2 clause 1 subclause A of the 10th schedule of the constitution. And secondly, the Supreme Court also stated that there was no violations of the principle of natural justice, that because here the so called notice was issued to him by the chairman of the Bihar Legislative Council, and after issuing notice he was also being given the personal hearing, and this is also admitted fact that he contested the 2004 parliamentary elections as a independent candidate after the refusal by the Congress party to give him the ticket. So, in such case he has incurred the disqualifications under the para 2 of the 10th schedule of the constitutions, read with explanation A to the para 2 clause 1 of the constitutions. Then after explaining the meaning of the voluntarily giving of the membership of the house, now I am coming to the other important issue that pertains, that has cropped up before the court regarding the what will be the status of the expelled member, because if some of the elected members indulge in anti-party activities, then that case that particular political party may be compelled to take actions against such members, and he may be expelled from the political party. So, suppose if any person is being expelled from the political party, or if he is being declared a detached member or unattached member of that particular political party or the house, then what will be their status? Whether such persons will have any kind of liberty to join other political party, at the same time he will also continue to be the members of that particular house without inviting the provisions of the anti-defection law. Here this issue was examined by the Supreme Court in the G. Biswanath versus Honorable Speaker Tamil Nadu Legislative Assembly way back in year 1996. Here the appellant was the elected members of the Legislative Assembly on the ticket of the AIADMK. And what happened that after elections, since he was not been given any portfolio, so he indulged in anti-party activity and he was expelled from the party, and after expulsion he joined the MDMK. So, once he joined the MDMK party, then his membership to the house was being challenged before the speaker on the ground that he had incurred the disqualifications on the ground of defections by voluntarily giving up the membership of that political party, and it was admitted fact that he was being expelled from his own political party for indulging in anti-party activity. With respect to this, here the Supreme Court has challenged the decision of the Speaker on the two main ground. The first ground on which he has challenged the decision of the Speaker was that the para 2 clause 1 sub clause A of the 10th schedule of the Constitution, which comes into play only on the disqualifications of the members by the voluntarily giving of the membership, but this is not his case because he is already being expelled from their own political party, that is AIADMK, and it is only after expulsions he was not having any choice but to join the MDMK. And the second his second contention before the court was that para 2 clause 1 will apply only when the member himself by his own volition has given the membership, and it has no application if he was being thrown out of the membership. But the Supreme Court has negated this contention by saying that as far the expelled member status of expelled member is concerned, it is a private matters between that particular political party as well as that particular candidate. It has nothing to do with the anti-defection law. But if after the expulsions or if they are being declared as the unattached member or detached members, if they joins any other political party, then definitely in that case they will be subject to disqualifications under the provisions of 10th schedule of the Constitution. And as far the power of the Speaker is concerned, here the Speaker can take a decision suo moto.
Very sorry to interrupt you, sir, because we are short of time over here, but in a future session definitely we can talk with the part which left over here, and we would be meeting again. Till then, dear friends, take care, goodbye, and thank you, sir. Thank you so very much.